皆様どうもこんにちは。弁護士の井上でございます。5月8日からコロナも2類から5類に分類変更になるなど、コロナ後に向けて社会全体が動き始めておりますが、皆様いかがお過ごしでしょうか。コロナの期間の3年間で米国訴訟の分野でも変化がございまして、コロナ後に向けて対応の必要のある領域もあります。本シリーズではコロナ中に日本企業を代理して米国訴訟でですね、手続きを進めた経験を踏まえて皆様にてどのような対応が今後必要になるのか明らかにしてまいりたいと思います。まず最初に弊事務所のトライアル弁護士チームをご紹介申し上げたいと思います。マーク・グッドマンですが、弊事務所のトライアルローヤーでございます。サンフランシスコオフィスにて勤務をしております。バリー・トンプソン、ロサンゼルスオフィスにてトライアル業務を行っております。ジェニファー・セムコですが、ワシントン DC オフィスにて、トライアル業務を行っておりまして、日本企業のですね、代理を進めておるところです。それぞれですね、自己紹介の方も申し上げてまいりたいと思います。Mark, would you kindly introduce yourself?
Thank you so much, Akira, and it's a pleasure to be here with everyone today. My name is Mark Goodman. As Akira said, I am a partner of Baker McKenzie in the San Francisco office. I am a commercial litigation partner and a trial lawyer with over 30 years of experience. I have done many class action and other jury trials in the United States, and I have managed many large-scale litigations during the course of my career, including for a number of Japanese clients. It's been my great pleasure to represent Japanese clients for all throughout my career. So I'm very excited to be here today and to share some of our insights on U.S. litigation.
Thank you, Mark. Barry, would you kindly share your experience and the background?
Happy to do so. Thank you, Akira. Great pleasure to be here with everyone. I often like to go after Mr. Goodman introduces himself because we have so much in common in terms of our practice. Like Mark, I've been a member of the bar for over 30 years, litigating and trying cases across the US. I am based in Southern California in Los Angeles. But as Mark indicated, we all try cases all over the place, have tried cases in many states in the US and in federal courts. Again, working with Mark, working with Jennifer, working with Akira, I've had the good fortune and pleasure of representing a number of Japanese companies and doing so with them at the present time. And I really enjoy it a lot and look forward to having the chance to speak to you all today and talk a little bit about what we've lived through with COVID and what's happening now. So my pleasure.
Excellent. Jennifer, would you kindly introduce yourself?
Absolutely. I'm Jennifer Semko. I'm a partner in the Washington, D.C. office of Baker McKenzie. I've been a litigator for 25 years now. Like Mark and Barry, I've litigated a variety of complex cases all around the United States, including representing a number of Japanese companies, both as the plaintiff and the defendant in U.S. litigation, oftentimes working closely with my three friends here, Akira, Mark, and Barry, on those cases. I've been proud to call Baker McKenzie my home for the last 22 years. And currently I chair the Washington, D.C. office's litigation and government enforcement practice. And I look forward to speaking with everyone tonight.
Thank you, Jennifer. And now bringing to the main topic, to understand what has changed as a result of COVID-19, we need to understand what was previously considered normal in U.S. litigation. And Jennifer, what can you tell us about that?
Well, when we think of U.S. litigation, our litigation in the United States is well known for a few unique things. Expansive discovery rights that include the right to take depositions of witnesses, very active motions practice in which A number of motions are usually filed in a typical case and argued before a judge prior to trial. And then lastly, of course, we are well known for our jury trials. And a typical case prior to COVID would have featured these three activities in person and almost exclusively in person. So for example, in a typical case prior to COVID, you would have a number of in-person depositions of witnesses for both sides and depositions of third parties. In a typical case, you might have up to 10 depositions for each side, maybe even more. And those depositions would be scattered across the globe, witnesses traveling around the globe to participate in depositions. And significantly, counsel and the witnesses and the court reporter and the videographer would all be together in the room for the deposition, sometimes for days on end, if you're talking about a situation where multiple depositions are being conducted. And in that room, we, the lawyers, would have the opportunity to sit next to our clients during the depositions, to guide them, to give them assurances, to read their reactions and adapt promptly, really quickly to what's happening in the room. And when taking a deposition of a witness, we would be looking that witness in the eye just across the table, which obviously has a lot of benefits in terms of an effective deposition. U.S. litigation, as I also mentioned, typically features a lot of court appearances. And pre-COVID, those would almost exclusively be in person. This could include status checks, what we call status conferences with our judge every few months, hearings on early motions where the judge would hear oral argument from the counsel or hear about discovery disputes that are happening, again, in person. And for better or worse, these kinds of court appearances would often involve traveling to and from the court and sitting and waiting for your case to be called. And that could mean that a 5 or 10 minute appearance before the judge would involve 2, 3, 4, 5 hours of a lawyer's time. Mediation and settlement conferences, either before private mediators or before the court, those historically have always been in person too, because mediators and courts really have not historically been set up to conduct those kinds of settlement talks virtually. So this would involve bringing the parties together in the same building, and sometimes that close proximity would allow the parties to bridge gaps, to resolve differences that previously could not be resolved. And then lastly, of course, our jury trials. Our jurors are pulled from the local community, and there has historically been an extensive in-person process to question and select the members of the jury. And then once the trial begins, the jury proceedings are of course held in a courtroom, typically in person over many days or weeks. The jurors are physically seated in a box section, usually just feet from the witness and the judge. And this gives the jurors the opportunity to, again, just like we would in a deposition, look that witness in the eye and judge for themselves the truthfulness and the credibility of that witness with no distractions around them. They are very much stuck in the courtroom, focused exclusively on what's happening in the trial. And as you'll hear from Mark and Barry, COVID brought a number of significant changes to many of these normal litigation practices.
Excellent, Jennifer. So how did COVID-19 change litigation in the normal U.S. litigation? What challenges have U.S. trial lawyers like you faced, Mark?
Yeah, Kira, good question. And just to follow up on what Jennifer said, as she laid it out, there was a huge difference between now and pre-COVID. Certainly during COVID, nothing was in person. All of those activities that Jennifer just described were not happening in person at all, and many of them were being delayed until there was more clarity with respect to what COVID would bring. Now that we've emerged in the United States out of the COVID pandemic, there's been a gradual shift back to more in-person activities in litigation. But I think it's safe to say it's really changed forever the way things have happened after the pandemic, mostly due to the medium that we're on right now, which is Zoom. Zoom, Teams, other video conferences have really allowed those in-person meetings, status conferences, some of the other activities that Jennifer mentioned to be conducted remotely. So instead of flying from San Francisco to New York for a 10-minute status conference and then flying back to San Francisco like I did in 2019 and for years before that, now almost all courts have such conferences virtual by video. The trick for us as trial lawyers representing our clients to the best effect possible is to try to push for certain activities to be in person, because now it's more up to the judge. So some judges will have hearings remotely, and you want to have an important hearing like a motion for summary judgment or a motion to dismiss a piece of litigation in federal court. You really want to have that argument in person because it's much more effective to be in front of the person that you're trying to convince rather than being on a screen. There's a lot of anecdotal evidence to show that that's the case, that human beings respond better to in-person advocacy. So the trick for us is to try to push courts to make sure that the important motions are heard in person. Trials are almost always conducted in person. Jennifer and I had a case in New York with a judge who was going to hold a trial virtually. That's his decision. He was going to make sure everything was virtual. So there are still judges who are pressing for conducting things virtually, and it's sort of up to us to make sure things are being done in person. We also have strategies with respect to whether depositions should be conducted in person or not. We like to take depositions in person and defend depositions virtually so that the other side is on camera. And if we can get away with that, that's our strategy. There are obviously some tactical decisions that go to that and that form a basis for strategy that we will discuss with our clients. But it's clear that how cases are litigated in the US has changed. I mean, there's still the same motions, the same discovery, the same trials that Jennifer described. It's just how they're conducted is changing and has changed, and I think permanently, with respect to how we're going to be doing things in the future. And it impacts the strategy of the case and how we work with our clients. There are some good aspects to it, which include cost savings and time savings, but there are also some aspects that are not so good that we have to try to fight against and make sure we can do things in person.
Great, Mark. Now, Barry, would you kindly share your insights and observation, especially whether or not all things have returned to normal, before COVID-19 situation?
Absolutely, Akira. The answer is no. as Mark and Jennifer Mark was stating directly, and I think Jennifer was implying, we really are in a new normal. And I think that's probably the way we need to think of it. The olden days of everything in person, long tours across the country are gone. What I think we have to try to do as trial lawyers and as litigation strategists is we have to, as Mark was picking up there, we have to figure out the places where we can score the most points in our litigations. We have to figure out the places that are going to help us bring the right facts in front of a jury. So for example, as Mark and Jennifer were alluding to, when we take depositions now, we prefer to take the depositions live if we can. So we're in the room, we can read the witnesses and kind of react to the witnesses. But some witnesses will, to this day, insist that they don't want to be deposed unless they get to mask up. All right. I personally hate taking a deposition of someone in a mask because I can't tell what their true reaction is and figure out where to go with my questioning, or if they're, telling me the truth or not. So in that instance, depending on the importance of the witness, you may decide to take a video deposition instead. If you do a video deposition, there are pros and cons to that. You do essentially have a full-time picture of them. You can see them without a mask on now, but you have to prepare extremely well in terms of all the documents and exhibits you're going to use for the deposition, and you generally have to turn them over to the other side. You don't absolutely have to do that. You can try to project them up on the video screen in a deposition, but if you do that, you give over a certain amount of control to the witness. And when you're usually on cross-examination, you want to control the witness. So these are the kind of things that we're having to confront in this new normal. That was not a problem back in the day. You got to sit next to the witness and hand them the documents, go through them as long as you wanted, and read them in real time. And this is just one example. It's really a factor of, if you like to be in the room and you feel like you can have an effect in the room, right? If your very presence in a room can be effective, this new normal can be a challenge unless you can convince a court to let you go live, right? Because you can only be so effective on video. And we all know it. When certain people walk into the room, there's a presence, there's an aura about them, and that is lost on video, right? So we have to try to control those settings in the litigation process and find ways to take that control back, even if we're forced to use video for certain portions of a proceeding or discovery. So I think those are among the biggest challenges for us now and the biggest changes in the new normal.
Great, Barry. So based upon each of your experience during pandemic and in light of your prediction for the future, what are your recommendations for Japanese company to better deal with future US litigation? Mark, would you kindly share your observation?
Happy to, Akira. So I think first and foremost, it's important to have counsel that's experienced with the kind of work that Jennifer, Barry, and I described in the first part of this video session. You need to understand how things work. You need to somebody who understands the pluses and minuses that Barry just described in the strategic advantages and disadvantages for a client. So having that lawyer, that outside counsel that really has the experience both in person and remotely in how to try cases, how to manage litigation, is going to be even more important than ever in the new normal, as Barry called it.
And I would echo what Mark said. That trusted advisor is really crucial in the current environment. You need someone who's up to speed on the local court's practices and requirements, some of which will be changing rapidly every day. So someone who's keeping up with those changes. As Mark mentioned, there are going to be some times when a virtual proceeding is the best choice. Maybe it is a less consequential motion and you need to save some of your costs. But there are going to be plenty of times where a normal in-person proceeding is crucial, even if it's going to be more costly or less convenient. And those are the kinds of issues that you really have to talk through strategically with your trusted advisors.
A great point, Jennifer. No doubt that each of us are comfortable in a courtroom, comfortable in front of a judge, and would always prefer to be there with a judge or jury if we have our way. We know that we don't always get our way with judges. As compelling as we think that we are, we sometimes can't compel the judge to go with what we want. So you really have to maintain a flexibility and an ability to react and adapt to what your court will allow you to do. And I think in working with Japanese clients, all of us know that the better we can prepare the clients for the possibility of things not going exactly as we would script them if we had our way, and to give us a little bit of flexibility to try to negotiate that best path forward and the best way to present our positions. That is something that I think, again, picking up on the concept of once you have the trust of your client and your client understands why, because you've explained it, that you want to go in a particular direction, you can be most effective in US courtrooms. So that would be my suggestion.
Thank you, Mark, Jennifer, and Barry, for valuable advice to Japanese clients. 皆様、本日はご清聴いただきましてありがとうございました。本日ご紹介申し上げた3名ですが、US Litigation のベストストラテジストでもございます。このシリーズではですね、コロナのですね、期間中に得た教訓などをもとにですね、皆様にて、どういった対応をしていったらリティゲーションのですね、リスクを抑えられるのか、あるいは、仮にリティゲーションに巻き込まれた場合のですね、インパクトをですね、どうやってミニマイズできるのかといったですね、ティップをですね、皆様とご共有を、していきたいというふうに考えております。引き続き、弊事務所のですね、ビデオシリーズをですね、ご清聴いただければと思います。本日はどうもありがとうございました。Stay tuned with Baker & McKenzie. More to come. Thank you.